The law of general average is a legal principle of maritime law that has existed as a part of international trade since ancient times. According to the law of general average, all parties in a sea venture proportionally share any losses resulting from a voluntary sacrifice of part of the ship or cargo to save the whole in an emergency. The purpose of this law is to ensure that a party who has suffered some extraordinary expenditure or loss in order to save property belonging to others has the right of compensation for its loss from all parties that benefited from that voyage. The risk is spread among all the owners of the cargo and the owner of the vessel. The official law of general average states, there is a general average act when and only when any extraordinary sacrifice or expenditure is intentionally and reasonably made or incurred for the common safety or the purpose of preserving from peril the property involved in a common maritime adventure. Therefore, a situation can only be declared general average if the voyage was preserved from peril. If the entire voyage is lost, for example, if the ship sinks, this would not be a general average event, since the voyage was not preserved from peril. It is up to the captain of the ship to make the official declaration of general average. Some examples of situations that can result in the declaration of general average are a fire on board the ship, mechanical engine failure, the ship running aground, a case of piracy or ransom of the ship, or getting caught in a storm that forces the ship to find an unplanned safe harbor. All of these events would require the ship's crew and outside parties to take action to save the ship, its crew, or its cargo in order to complete the scheduled voyage. As you can see, all of these example situations are unpredictable and can happen to any crew despite their level of experience on the sea. If you are shipping goods via an ocean vessel, you are party in that sea venture and are at risk of a general average claim. Once a ship captain declares general average, all parties become part of the claims process. The law of general average is a legal principle of maritime law that has existed as a part of international trade since ancient times. According to the law of general average, all parties in a sea venture proportionally share any losses resulting from a voluntary sacrifice of part of the ship or cargo to save the whole in an emergency. The purpose of this law is to ensure that a party who has suffered some extraordinary expenditure or loss in order to save property belonging to others has the right of compensation for its loss from all parties that benefited from that voyage. The risk is spread among all the owners of the cargo and the owner of the vessel. The official law of general average states, there is a general average act when and only when any extraordinary sacrifice or expenditure is intentionally and reasonably made or incurred for the common safety or the purpose of preserving from peril the property involved in a common maritime adventure. Therefore, a situation can only be declared general average if the voyage was preserved from peril. If the entire voyage is lost, for example, if the ship sinks, this would not be a general average event, since the voyage was not preserved from peril. It is up to the captain of the ship to make the official declaration of general average. Some examples of situations that can result in the declaration of general average are a fire on board the ship, mechanical engine failure, the ship running aground, a case of piracy or ransom of the ship, or getting caught in a storm that forces the ship to find an unplanned safe harbor. All of these events would require the ship's crew and outside parties to take action to save the ship, its crew, or its cargo in order to complete the scheduled voyage. As you can see, all of these example situations are unpredictable and can happen to any crew despite their level of experience on the sea. If you are shipping goods via an ocean vessel, you are party in that sea venture and are at risk of a general average claim. Once a ship captain declares general average, all parties become part of the claims process. The law of general average is a legal principle of maritime law that has existed as a part of international trade since ancient times. According to the law of general average, all parties in a sea venture proportionally share any losses resulting from a voluntary sacrifice of part of the ship or cargo to save the whole in an emergency. The purpose of this law is to ensure that a party who has suffered some extraordinary expenditure or loss in order to save property belonging to others has the right of compensation for its loss from all parties that benefited from that voyage. The risk is spread among all the owners of the cargo and the owner of the vessel. The official law of general average states, there is a general average act when and only when any extraordinary sacrifice or expenditure is intentionally and reasonably made or incurred for the common safety or the purpose of preserving from peril the property involved in a common maritime adventure.
Good day, everybody. I'm talking from Interlegal Studio from Odessa, Ukraine. My name Mykola Melnikov. I'm a partner at Interlegal. Today we will have a great international webinar dedicated to General Average. General Average, probably the oldest legal institute that we used up for today, and probably the most complicated. We already saw very interesting 2.5 minutes video related to general average, and looks like we know everything about general average now. What do you think? My personal view that we can talk about general average 2 minutes or 2 hours or 2 days, and the topic will never end. We choose second option for today. We will talk 2 hours. 190 delegates from 45 countries of the world are joining our webinar today, and they represent all participants of the transportation chain: ship owners, ship operators, cargo side, brokers, managers, marine insurance people, legal professionals, and many, many others. So, good day again. Доброго дня, шановні, слава Україні. Let's start for my short presentation. One moment, please. О, пошло. Oh. So this is the topic of our today event. Today we have 4 media partners: Shipping Magazine, APK Inform, RDL Group, and Ukrainian Shipping Magazine. Thank you very much for your support. Today we will have 2 speakers: Richard Faint, maritime arbitrator, supporting member of the London Maritime Arbitrators Association, arbitrator at London Court of International Arbitration. And the second speaker, Yavor Velchev. Yavor lives in Burgos, Bulgaria, and he is founder at Ship Possible Ltd, consultant in marine insurance, legal, and claims. Richard and Yavor will cover all aspects of general average, or try to do it. And after, we will have 4 panelists. I will introduce them a little bit later. And all these gentlemen will connect each specific part of General Average Institute. A few words about Interlegal, about our company, which is organizers of today's event. Our mission is to be useful for transport, shipping, and international trade people in their fair business. Our key practice is shipping, transport, port and terminals, international trade, yachting, and other. We are Black Sea law firm. We have offices in all Black Sea countries. We have no office in Russia, but in all other countries, we have our own offices. And to serve our clients all over the world, we have firm relations with 60 plus associated offices worldwide. Our key numbers, you can see 1,000 cases per year, etc., etc. So we try to do our best for our clients. Special thanks to Black Sea Institute of Shipping and Trade Law, which is our main partner in organizing of today's event. But the great and the biggest thanks I would like to say to Ukrainian soldiers who keep our safety all the day and all the night. We had 3 air alarm during last night because of Russians' rocket, but all rockets were destroyed before coming to their aim. Thank you so much again. And let's start from our, one moment, please. Yes, let's start with our program. And the first speaker, I will introduce again, Richard Faint from London, Great Britain, maritime arbitrator. And his presentation has a very, very simple name. What is general average? Richard, please, floor is yours.
Thank you. Thank you for the introduction. And here we go. Let's see. Right. Well, the small introduction that we've already seen, good morning to everybody, sorry, is a fairly broad overview. I will try and expand a little bit on that. Yes, general average, GA, principle of maritime law, where in an emergency, cargo can be thrown overboard, or where expenses are incurred to save the ship or cargo. As said in the little introduction, the loss is shared proportionally by all parties with a financial interest in the voyage. That is important. And already we have a little problem. In the test 5 minutes ago, this worked perfectly. Bear with me.
Richard, just one click in your screen.
I just tried one click. Let's see. Try again.
What right now? One click, please. No?
No.
Left click, not right.
Left click, please. Left.
Let's click. Okay. Let's try again. As the introduction said, GA is connected to the contract of carriage. It often gets confused with insurance, and this is quite an interesting point. Do not get confused. General average exists outside of insurance. We should not forget this. So let's make some comments on this. Average in marine insurance means loss, accidental loss. Beware, in the first instance, such loss will lie where it falls. In plain terms, it falls on your shoulders. Insurance cover, if you have it, can transfer that loss to underwriters. You make a claim on your insurance. Such a loss is called a particular average. We'll use the term PA. Insurance losses are either PA or total losses. As the little example said, if the ship sinks, there's no GA, it's a total loss. Back to GA. The principle is very logical. The law of GA is an independent branch of maritime law, distinct from carriage of goods by sea and marine insurance. Let's be careful here. The rules of general average are not an international convention involving governments adopting rules. York Antwerp Broad, which we'll come to a bit later, are effectively a convention which has done away with politicians. People use GA because people have always used GA. Okay, let's continue. This is interesting. The Brighella in 1893, the head of the court said, the obligation to contribute in GA exists between the parties to the adventure being the sea voyage, whether they are insured or not. The circumstances of a party being insured can have no influence upon the adjustment of the GA, the rules of which are entirely independent of insurance. I hope that's clear. It's correct to say GA has existed for ages and before the practice of insurance was known. This explains why it does not depend on insurance law or any other branch of law. Liability in GA before 1906 arose at common law. I'm speaking about English law. After the Marine Insurance Act of 1906, liability in GA arose by statute, no real change. Today, the law of GA is regulated by the Marine Insurance Act, Section 66, 661, and the terms of your insurance policy and the York Antwerp rules, of which more later. I would point out I am not an average adjuster. I have some understanding of the GA principles, but I'm not an adjuster. Better people will speak later on this subject. So it can be confusing. While GA is outside of insurance law, the best definition of GA can be found in the Marine Insurance Act, Section 62. We've already seen this, where there's a GA Act, extraordinary sacrifice or expenditure voluntary and reasonably made, incurred at the time of peril for the purpose of preserving the property imperiled in the common adventure. Okay. Again, we look to what the courts have decided, and this is ancient law. This case is 1805, Berkeley v. Presgrave. All loss which arises in consequence of extraordinary sacrifice made or expense incurred for the preservation of the ship and cargo comes within GA and must be borne proportionally by all who are interested. Okay, so I hope everybody's still with me. General in GA is taken to mean that the loss is to be generally distributed. And this is it's the difference. It distinguishes it from PA, a particular loss in insurance. Examples: throwing cargo overboard. In English, this is called jettison, to keep a vessel afloat until it is rescued. The cost expenses of deviating from a voyage to go to a safe port. We saw that in the little diagram. Can you spot the difference? I've put here the example Mondo. I'll just briefly give you a rundown of this case. A cargo loaded in Turkey to go to Ireland. The bills of lading were issued, the cargo was loaded, the voyage started. Before she got to Gibraltar, there was a problem. She went to Gibraltar as a port of refuge. So we're not far. We haven't gone very far as a sea voyage. It turned out that the ship was not seaworthy. The master declared GA on arrival in Gibraltar. The hull of the ship had suffered up to 70% steel wastage. The ship had not been maintained for many years. GA security was provided. Cargo underwriters then declared the ship to be unseaworthy. The GA was not allowed because the ship was unseaworthy. The average adjusters amongst us can come back to the story a bit later. Cargo insurance covers accidental physical loss or loss of or damage to goods or the ship. Okay, we're happy with that. Here we are talking of accidental loss. But in GA, we are dealing with losses that arise from deliberate acts, the act of throwing some cargo over the side of the ship to keep the rest of the ship and cargo safe. This is the difference. Deliberate acts. GA deals with intentionally incurred expenditure or sacrifice which benefits the others. Your cargo may be thrown overboard. That benefits the cargo which remains on board and the ship and the crew. This is the difference. So it makes sense that those who benefit pay something to those who have lost something. This is GA. GA is unique. Your property can, as part of a marine adventure to sea voyage, become liable to contribute to the loss of somebody else's property. A little bit difficult, a little bit confusing, but this is the way it works. This obligation is binding, whether you are insured or not, and no matter what your nationality is. GA is an international agreement. Your cargo insurance will cover this liability if you have it, and will pay any GA contribution, but only as an indemnity. Okay. So here we come to the interesting bit. GA is also referred to by the name of the international rules, or an international set of rules, the York-Antwerp rules. Important to be aware of the York-Antwerp rules because they set out in great detail the way GA is applied. This is where most non-claim specialists get confused. The York-Antwerp rules, if you look at them, you will see why even High Court judges in England have problems with GA. The latest version of the York-Antwerp rules, 2016. I leave the complexities of this to a real average adjuster, but I'll make some comments anyway. York-Antwerp origins. International conferences, first held in 1877, named after the places where the conferences were held, roughly every 20 years, so various versions over the years. Last held in Vancouver in 31st of May. They revised the York-Antwerp Rules 1994 and approved a new text to be known as the York-Antwerp Rules 2004. The intention was to apply York-Antwerp Rules 2004 to the adjustment of any GA. It should have come in after 31st of December 2004. The 2004 rules, I think it's safe to say, were not a great success. They did not really take off. They were the poor acceptance. And now we have the York-Antwerp Rules 2016. Even more confusion possible. Be careful. These rules, these things do not change quickly. It took 9 years to go from the 1994 rules to the new set in 2004. 2004 rules do not appear to have been greatly well received. But if any if they are to govern, any rules are to govern a GA adjustment, they need to be incorporated into the Bill of Lading and Charter Parties. I say this because there may well be claims where the York-Antwerp rules, or more probably the 1994 rules, still apply to the contract. And we have to bear in mind that GA applies by reason of the contract, by the Bill of Lading, by the Charter Party. So here we go again. So the aim of the York-Antwerp rules is basically to unify everybody's rules so that GA is the same wherever it happens and wherever it is adjusted. It's not a convention, as I said. No country has adopted them into domestic law, but they are successful. It's a successful set of rules because almost everyone is content to agree carriage contract incorporating York-Antwerp rules. But be careful which set of rules will apply. They're brought into effect by being incorporated into the contract, and that's the first place to look, the Bill of Lading and the Charter Party. However, in the absence of agreement, the law of the port where the adventure ends is to be applied. Again, the average justice and Munsters can expand on that. So although GA is based on a simple principle, its application to the unlimited possibilities of problems have given rise to many variations of usage at different periods and in different countries. Local domestic law may have a variation on English law and practice, so you have to bear that in mind. So in brief, this simple principle could not be applied in any settled or consistent manner without the York-Antwerp rules, even if they seem to the non-average adjuster to be technical and sometimes arbitrary in character. And I have often felt confused by looking at the York-Antwerp rules. So let's be clear in this. GA is not the same thing as a simple loss, a particular average where you can go to your underwriter. GA can be distinguished from particular average, PA, because general average is a special circumstance where the loss does not lie where it falls. Under GA, there's no need to show liability in tort or contract, and the GA loss can be spread ratably, proportionally amongst the parties participating in the marine adventure at the time the loss is incurred. And I would add here, we're talking of the hull and the cargo, but if you are a time charterer, you own the bunkers on board, so they will contribute as well. So it's an old idea to spread the risk of marine voyages. It's an early type of mutual insurance, and marine insurance is perhaps the most ancient form of insurance. Here, a little bit of history. Early Egyptians insured vessels against disaster. Babylonians did it about 2,300 years BC before Christ. I've given the code of, if I pronounce it, Echumanrabi in the details. So over 4,000 years ago, early traders, and we're all interested in international trade, that pays the bills, early traders practiced a form of insurance known as bottomry. Basically, this was a mortgage on the hull of the ship, and meant that the ship owner would be indemnified if the vessel was lost, but paid over a substantial part of the profit of the voyage if the vessel safely reached its destination. This mutual way of covering risks was current practice for centuries. Ancient Greeks perfected it, and Romans had a similar system. Here, I'm having a little bit of a joke. Plutarch, 148 BC. Marcus Cato, Cato the censor, a great money lender. And he used to loan money in what is surely the most disreputable form of speculation, that is the underwriting of ships. Has much changed? Well, unsurprisingly, traders' opinion of underwriters has changed little since these times. But you can see that people look to insurance as a means of spreading or reducing the risk. In olden days, and even during my time at sea, a captain had very wide powers of action in time of peril. The invention or introduction of mobile phones has perhaps reduced the power and authority of a master, but that's a completely different story. In times of peril, this is lawyer speak, legal speak, for a time when something has gone badly wrong. At this time, the captain is effectively left holding the baby. He must make executive decisions, probably without being able to contact anybody on his mobile phone. He's the man on the spot, and he knows that he has to make a decision. He may, if necessary, sacrifice property or incur expense for the general safety of the ship, crew, and cargo. Okay, we're happy with that. So, to help understand what sacrifice in difficult circumstances is, consider what is meant by jettison. So today, jettison, throwing overboard cargo in heavy weather, is somewhat uncommon. Before bills of lading introduced in the 16th, 17th century, sea voyages were real adventures with a high risk of something going wrong. Sailing ships were at risk of bad weather. At that time, all parties in a maritime adventure, ship owner, cargo, captain, and probably the traders, were all present on board when and if a ship got into difficulties. In difficult circumstances, a captain could decide that the only way to save the ship, jettison the cargo. The owner of the doomed cargo might agree to this action, provided always that everyone involved contributes to this loss. This is the principle of GA. If it works, the cargo jettison floats away, is lost. but the ship reaches the harbour safely, where the lost cargo is then valued, and everyone involved, ship owners, cargo owners, including the owner of the jettisoned goods, contributes according to the degree in which they had benefited from the sacrifice. GA contribution is calculated by dividing one value into the value of the others. It's mutual insurance of a primitive but effective kind. Without GA, it would be unfair, since the owner of the jettisoned cargo would have to bear the whole of the deliberate loss incurred for the general benefit of all the others involved in the voyage. So such a loss is called a general average loss, or a general average sacrifice or expenditure. GA described as pure jettison is straightforward, but today it's more complicated. From the 19th century, the rules agreed that GA includes expenditure as well as sacrifice. A case could involve towage of a ship, disabled after a fire, expenses and repairs in a port of refuge, and maybe the on-carriage of the cargo. Typical costs of a GA fall firstly on the ship owner, and claims are often made against the cargo. So assume a ship has run aground. If it stays aground, a storm may break up the ship on the rocks, so all the ship and all the cargo would be lost. To get the ship back into deep water may require the use of her engines to such an extent that those engines are damaged. In such a circumstance, the ship owner can ask for a contribution to make good this damage. He asks a contribution from the cargo owners. Be careful. Only loss voluntarily incurred for common safety can be claimed. Damage incurred by a ship going aground is not a GA situation. Financial sacrifices subsequently necessary to get her out of that danger would be a GA expense. Again, I'm sure the average adjusters will go through that in more detail. So this all sounds very simple in theory, but in a real situation, practical application can be complicated. I'm going to give a brief example. I'll go through this quickly because, as I say, I'm not an adjuster. So shipper A has a GA loss of 1,000. I'm using pounds. Average adjuster. An average adjuster is appointed who establishes the total cost of the ship and cargo, say 3 million. Shipper B, whose cargo was not damaged, but value assessed at 3,000, would be asked to contribute. That's the calculation. So shipper B pays £1 as his proportion of that GA contribution. That is it in principle. In practice, it takes time to calculate. In fact, it may take several years. I'm going to ask you to think of a case called the Napoli. And this is a picture of a ship, a container ship that went aground off the English coast. It had a number of containers on board. 2,000 containers were removed. Some containers were lost. You can see the effort and the work involved in saving this ship, saving what was undamaged cargo. Just look at the picture involved. 58,000 tons of water were pumped from the hull, anti-pollution vessels, a barge, a lead tug. There were other tugs involved. Cargo washed up ashore, cargo to be recovered from the shoreline. Excuse me. It's a very complicated procedure. Sacrifice, expenditure, and contribution. There must be a GA Act within the governing definition and practice. GA will be declared at the end of the voyage. So when does the GA Act arise? Go to York Antwerp Broads, Rule A. The GA Act, when and only when extraordinary sacrifice or expenditure is intentionally and reasonably made or incurred for the common safety. Okay, we understand that. GA sacrifice and expenditure shall be borne by the different contributing interests on the basis hereinafter provided. Go to the rules. The GA declaration by the captain must lead to a adjustment carried out by a professional average adjuster appointed usually by the ship owner, but not necessarily so. The average adjustment, when it's published, will show the contribution to be paid by every party at risk. And the ship owner is responsible for collecting all the contributions. The owner generally has a lien on cargo and has the right to demand security for his claim. This is where fear and confusion normally creeps in, because in theory, the ship owner can demand a GA contribution before he parts with the cargo, but he does not know at that stage what that contribution will be, and cargo may have been sold many times while at sea, and the new owners of the cargo, the holders of the bill of lading, may not yet know of the GA incident. To avoid delay, the ship's agent demands from the cargo interest or the property that's involved a Lloyd's average bond and an unlimited GA guarantee. Both the Lloyd's average bond and the GA guarantee are separate contracts. Room for more confusion, but they are separate contracts between the ship owner and the cargo receiver. The Lloyd's average bond and the ship owner and the cargo underwriter, the GA guarantee. Normally, the ship owner accepts an average bond in return for the receiver agreeing to pay a GA contribution, worked out under the average adjustment. An average bond may also extend to salvage awards. Lloyd's average bond, a standard form agreed between London underwriters and the Association of Average Adjusters. GA bonds are different. They're usually in unlimited form, unlike a bank guarantee, and do not have a limited life or requirement to be renewed. There are time limits in the York Antwerp rules. The average adjuster amongst us could take you to that. GA, an act which creates a mutual compensation based on general average. That's a GA Act. An emergency expenditure which qualifies under the principle of GA, which gives rise to proportionate contribution to the others involved having to make a payment, is called a GA expenditure. And a contribution from a person towards the loss of another is called a GA contribution. So the York Antwerp Broads, to come back to this, International Convention on Work and the Law of GA in practice exists. It's managed by the Committee Maritime International. They're based in Antwerp. Understanding GA and applying it are two different things. Each case involves jurisdiction issues. I mentioned this before. Your domestic law may have a variation. So jurisdiction issues, interest, contribution, and other details. The adjustment is subject to the workings of insurance adjusters and appraisals. Most cases settle, or as was stated by Justice Collier, the judge in a Canadian case of Northland navigations, most claims do not go to litigation. Here is an interesting example. A case 1922, Watson's and the Fireman's Fund Insurance. A cargo of rosin loaded on board the vessel, the Sophie Frankel. It then overheated due to steam escaping from a fractured pipe. And from the captain's point of view, here I ask you all to place yourself on deck. The captain's point of view was the smoke was being given off by this cargo. The captain on the deck at the time in this on the day believed that the cargo in the hold was on fire, and he put steam into the hold and damaged the cargo. Yeah, we're going back to 1922. Question: was this a time of peril? Was there any real danger to the whole adventure that gave rise to a GA condition? Think about it. The captain is on deck. He sees smoke coming out of the hold and decides to take steps to deal with what he believes to be a fire. So he declared GA. 1922, no mobile phones, no email, no internet connection. Answer: the court decided this was not a GA incident. It was a mistake on the part of the captain. There was no fire in the hold, and the damage done to the cargo was not a GA situation. I'm using this as an example to show the weight of the decision that the captain has to make. Another example here. The SS Bacchus had her propeller found by wreckage on a voyage from Bordeaux to Cardiff. She put into Cherbourg for repairs. No dry dock was available, so she was tipped over onto her side in order to carry out repairs. This is an old case. We're not talking of giant ships. The repairs required some of the cargo to be removed. A derrick and foremast were broken while loading at Bordeaux, and a derrick toppled into the hold. The derrick was replaced and other repairs were necessary before she left harbour. Shipowners claimed these expenses as GA. The GA claim was contested. It went to court after going to arbitration. This is where my interest came in. Question to all of you: was this a real GA incident, as neither the ship nor her cargo was at any time in immediate danger? The answer, straightforward. The first breaking of the foremast and the toppling of the derrick into the hold did not of itself render any particular particular damage to the ship or cargo. It was not a GA act in having this damage repaired. Second, the court found that the fouling of the ship's propeller did constitute a distinct peril to the ship, cargo, and freight. Therefore, the act of taking the ship into a safe harbour and repairing such damage was a GAA expenditure and subject to contribution from all those interested. The judge actually found that the arbitrator was wrong in law when he placed unwarranted weight to the requirement that the ship be in immediate danger, and his words are worth noting. It is not necessary that the ship should be actually in the grip or even nearly in the grip of the disaster that may arise from a danger. It would be a very bad thing if shipmasters had to wait until that state of things arose in order to justify them doing an act which could be a general average act. Again, you can see the weight of pressure put on a captain, on a master. If he can see something is to be done before the danger increases, he has to do it. Remember, I'm an ex-mariner, so I'm always biased towards a master in a moment of danger, making a decision and standing by him. That danger must threaten the whole. That's the danger must threaten the whole of the adventure remains the case, even where a part of the cargo has been discharged, and then some danger arises that threatens the whole of the adventure as it stands, i.e. the ship and that part of the cargo still on board. I've gone quickly through GA, trying to keep it as practical as possible. I will give you one example more. I don't have a slide for this because it's a story of one of my own cases. I was once called down to a ship which had gone aground off Sicily. There had been a fire in the engine room. We got the ship off the rocks. We got her into Syracuse, and the story unfolded. The owner declared GA, as you would expect. We then discovered that all of the engine room doors on the ship were missing, and that the crew had their bags packed when the tug arrived. My boss, the master, the chief engineer, first mate, and one other were arrested. My boss at the time told me to go into the prison in Syracuse and take statements. I told him that I was not going to go into that prison unless he could give me a guarantee that I could get out again. The fire was deliberately started at a time when freight rates were low. The object of the exercise was to take the ship off the freight market, have repairs carried out, and hopefully by the time those repairs were carried out, the freight market could increase. So yes, to my mind, it is possible that unscrupulous ship owners may try and use GA to improve their position. I throw that open for discussion. As I say, I've run through GA quickly, and I hope I've removed some fear and confusion. I now open the door to other people to correct where I've gone wrong. Thank you for listening.
Thank you very much indeed, Richard. We have now one question related cargo damaged, but I offer to touch this question when we will talk about cargo interest a little bit later. Cargo interest in general average, I mean. So thank you again, and let's go to our second speaker. Yavor, are you here?
Yes.
Yes.
Well,
let me introduce you again. Yavor Velchev. Now he lives in Burgas, Bulgaria, and he is consultant in marine insurance, legal and claims. And his presentation names General Average, the Black Magic in Shipping. Yavor, please, floor is yours.
well, hi everybody, and thank you, Nikolai, for your wonderful presentation. I'm very pleased to be here, and I'm especially pleased to step in after such a renowned practitioner such as Richard Fain had explored well, of course, anytime. You've so well explored the background and the construction of general average in terms of its origin, how it's administered, which rules apply, etc. So what I will do my best to deliver right now is to complement Richard's presentation into a few aspects that he may not have mentioned. That's not because he did that deliberately. It's just that I will try to touch upon some other aspects, and I'll go into a case study towards the second part of my presentation. So let me first share my screen in order for everybody to be able to see the PowerPoint that I've put together. Is this now? Yes, okay. That should now be in full screen. Is that the case?
Please switch on slideshow.
All right. Okay. So that'll be home and then hold
Next,
on.
no,
Slideshow.
slideshow, yes.
Yeah, play
And-
from start. Okay.
Oh, perfect, perfect.
So again, the the title of this talk is Black Magic. I think I got inspired while I worked in Belgibo. I worked for a very big shipping company which still exists and operates fully. My previous employer was Euronav Exmar CMB in Antwerp, Belgium, where I spent 10 years as in the insurance department. So we at Ship Possible now do insurance, as Nikolai very rightly said. We arrange insurance policies for ship owners. We arrange insurances for charters and for cargo interests. And from that point of view, I will say a few words about General Average. But once we had a solicitor coming in the office, and he said, this is black magic, because it can be so tricky strategically, apart from being very complex. And that's how I entitled my talk. Now, what I've indexed here is a bit of etymology as to how that translates into various languages, modern languages. Why is it black magic? Who are the participants? I call them players here. What the process is, what documents are involved, what is allowed in GA. Sorry, I see some call. Oh no, sorry about that. What is allowed in GA? When is it payable? And the case report I mentioned. Now, let me. Okay. So who we are? Well, as I said, we are acting as insurance brokers and insurance consultants. Our clients vary from owners, charters, cargo interests. They are fully international, Europe, Middle East, Asia. So we do our best to deliver a boutique service. Again, etymology, when in the English language, and I think Richard has entertained you with that a little bit, but in English it's average. In French it must be avarie for the French speakers. Pardon my pronunciation if it's not intact. But in the Syriac languages that would be avaria. And I only actually thought about this while I was putting up the PowerPoint. I never thought that actually avaria comes from average. In my mind, average in English always meant something that's equal. Richard, you as a native speaker, wouldn't that be the case? If you say, well, that's average, you know, averagely. But I think average would, yeah, sorry. I think your microphone might be muted if you want to say something.
Richard, sorry, your microphone in mute now.
So,
okay.
Average in English is a mathematical word.
Yeah.
Average, but a number, you come up with a number. Average in insurance, completely different.
That's it. Okay. Well, thanks for the help. Indeed. Okay. Very well. So I've done well on that one. And why is it black magic? Because it can be complicated. There can be multiple participants with multiple demands and points of view. And I think mostly it's black magic because the circumstances are always so different and you never have one and the same story, as we will see further on. Now, who are the players? I've put in brackets stakeholders because in the context of General Average, each party has vested interests in a way in the voyage, but then different participation. Obviously, the ship owner being the carrier of the cargo is in play. The charter of the ship is certainly in that frame too. There can be multiple lines of sublets, so subcharters will always be involved in this as well. The cargo interests as well will take part. And then on the right side, I've referred to underwriters. Now, these underwriters could be hull underwriters for owners. and they can be liability underwriters for the charters. Now, all of you will know that hull and machinery underwriters, well, charters won't have any hull underwriters, but then the P&I clubs would act as liability insurers for the charters. For those of you who might not know, the clubs offer two main insurances, and these are protection and indemnity, and the other one, which covers legal costs, it's called freight demurrage and defense, or abbreviated FD&D. Now, who are the experts, i.e. non-underwriters or no direct participants? The experts would certainly be the loss adjusters or the average loss adjusters. The adjusters aren't any surveyors. Surveyors really are the on-spot experts who may fly to the place of incident and establish what the actual technical status of either the ship or the machinery or cargo or any other asset is. Very often you would find protective agents acting on behalf of ship owners, and often as well, the charters themselves would have their own agents at port of destination. The clubs usually rely on their own local P&I correspondents who would attend to practical matters. They would help the agents and ultimately assist their principals, the club and the ship owner, to arrange practicalities. So these are the experts which would be in the periphery of the events at play. Now, one particular aspect of the hull and machinery policies, which would administer the owner's cover, is the so-called general average absorption clause. I won't go into extensive details here, but basically this clause is an agreement of the underwriters to absorb an agreed amount, so that the owners will not make a GA claim against other parties. And in practice, in reality, that absorption clause can cover amounts up to, say, either 150K USD, 250K USD. Roughly, this is the practice where the GA absorption clause is laid down. Just try to... Yeah, okay. That would usually be with no application of policy deductible. So the GA absorption clause should be free of the deductible to eliminate, as far as possible, small GA claims. So this is a practical arrangement in order for everybody not to go through hell, but then the hull underwriters to have the courtesy, so to say, or the gesture offered to owners to simply absorb these so-called small amounts, which may not be small in another context, but in a multi-million dollar claim involving a lot of parties, then 150K may be small compared to $3-4 million. Okay. Moving on, just a few words about the role of adjusters, what they do, who they are. I think Richard has embarked upon this before me, but again, the adjusters, at least in the UK, are associated in the AAA, or so-called Association of Average Adjusters. They have their own rules of practice, which are pretty particular about every step through the process of GA. I'm going to, this is not advertisement at all, but I'm just going to pinpoint a few names. And of course, there are other offices across different countries, but these are just a few names which you may come across when dealing with GA. RHL is probably the most known one. They've been associated with some management companies and clubs before. In the UK, Rogers, Wilkin, Ahern, too. AIDE in France, Blue Sea Adjusting in Greece, Matthews Daniel, this is an international firm, Bjornslagen is an adjuster in Norway, Schliemann Siemens VHT in Germany, etc., etc. Why would each country have its own adjusting firms? Well, probably because some of you may know that the Holland machinery policies tend to have, how shall I phrase this, national policies. So you may see in the industry, you may see a set of English conditions. Okay, let's call them conditions. They are the very well-known international time hull clauses, which are the English conditions, but there are as well the Swedish conditions, there are the German conditions, the Norwegian marine insurance plan. So this is why in Norway, if the policy is issued, the hull policy is issued under Norwegian marine insurance plan, then it would be most apt for a Norwegian adjuster to interpret and enact the rules of the Norwegian plan into the specific GA situation. This is why the countries have their own adjusting firms in order to apply the applicable rules if the conditions are English, Norwegian, Swedish, even American or German. Right. So the process and what actually happens when GA is on our desks. Now, the triggering point, I believe, should be the declaration of general average. That is when the master of the ship, of course, in concurrence with the management office, in concurrence with the head owners, decides to declare general average. This is the triggering point. It is the choice of the owners to declare or not declare GA. If again the amounts involved are relatively modest, the owners may decide to turn to their hull underwriters and say, well, listen, we want to file this under our GA absorption clause because this doesn't really exceed 50, 60K. Would you be happy to absorb this? But if the amounts are bigger, then the owners will have to send a written declaration to the parties involved. And I've just given an example in this slide how a GA declaration may look like. It's pretty much a sentence saying owners declare GA, any costs to repair the PA, the particular average, will be dealt with in line with the York Antwerp rules, which are incorporated in the CP. So we declare GA and then we reserve rights to apportion costs and to send them to you. Now, when GA is declared, there's got to be a clear notion of the load port, discharge port, what and how much the cargo is. The owners may advise a little bit of the story and attach a GA bond and GA guarantee, which need to be executed by charters and the underwriters of cargo interests. Moving on, the owners will have to notify their underwriters about this. Probably the underwriters will appoint surveyors, and so will the charters. The charters will have to notify their underwriters. Now, in the example, the case example I'll show later, a transshipment has formed part of the story. Now, I've here mentioned the transshipment agreement because while I was going through my archive, I saw that there was a very deliberate and quite long transshipment agreement where cargo had to be transshipped from ship 1 to ship 2. And in that transshipment agreement, a lot of practical arrangements and a lot of aspects are laid down for the parties to be clear what happens and why. I've just here shown how an average guarantee looks like, and that average guarantee needs to be signed by the cargo underwriters. Okay. this is just for everybody to have a glimpse of what this looks like. As you may see, the second paragraph in bold reads non-separation agreement. I'll very briefly touch upon this later on. Next slide is the average bond. For the ones who haven't seen an average bond, this may be interesting. It very much looks like the average guarantee. Probably the main difference is that the bond has to be signed by the cargo receivers. You would see in the second paragraph here that a non-separation agreement also forms part of this document. What is a non-separation agreement? It very much and very generally says that when GA is declared, then the rights and liabilities of all the parties won't be affected by any forwarding of the cargo. So meaning that if the cargo moves from place A to place B, then the same applicability of the GA principle remains for all the parties involved, and there won't be any separation of these liabilities, nor there will be any separation of the rights and obligations of the parties. Wherever the cargo goes, in order to free up the vessel or space for the ship to be repaired and for the voyage to continue, then the GA remains intact, and the GA won't be separated in terms of how this applies to the parties involved. Okay, from owner's perspective, what is allowed under GA and what can the owners present to other parties, of course, after having passed this to their own adjusters? Owners can include in GA attendance costs. This would be surveyors, this would be experts, which we mentioned earlier. If cargo needs to be stored either in a floating storage, either ashore in a warehouse, then these storage costs would form part of the overall GA. Now, if STS ship-to-ship transfer must take place, then the unloading costs will be allowed in GA as substituted expense. If the auxiliary engines work, then the extra fuel from these auxiliary engines will be allowed in GA2. I've put in brackets here the Norwegian Marine Insurance Plan, because certainly under the Norwegian plan that applies. If owners have negotiation costs, and we've seen that in practice, these costs would be allowed in GA. This is a pretty exotic example, but ransoms would be allowed in GA2. Touch wood, that not to happen ever. In the event of tankering business, then the deslopping of tankers and these costs would be allowed in GA. Right. I hope I've given everybody a brief idea of which elements could be allowed in GA. The list is not exhaustive, but it just shows a few interesting examples. There is another interesting thing which I've just picked up from my archive. It was called GA interest. And now, if the owners make if the owners make the payment of their own apportioned part of GA, then the owners will also benefit from GA interest, which accrues from the date of payment until 3 months after the adjustment is issued, and 2% commission can be added on. That may be useful for owners to know if there are any ship owners among us, or even if not, charters may bear this in mind, that the owners, with the help of adjusters, may arrive at these things so that there are no surprises at the end of the day. When is general average payable? As a general rule, general average is not payable until the cargo is discharged. Usually there are a lot of operations carried out before the cargo is successfully and ultimately discharged. So GA won't be payable until then. Right. Here we arrive at the case study that I've prepared for you. I hope we are moving fine with time. Nikolai, how are we? It's 1:15 now. Do I have about 10 minutes to go through this?
I guess we have not more than 5 minutes, please.
No worries. No worries. Okay. Right. So in this case, we have a typical bulker. The charter party is NYPE 46. There is a voyage charter down the line, and what happened is that the main engine of the ship broke somewhere last year. The onboard cargo was 20,000 metric tons, and what class said is that the main engine shouldn't be used until further establishing of how the shafting and sealing are arranged. So technical stuff. Class said, don't use the ship. Owners declared GA. The vessel value was 15 million. The cargo was 6. Bunkers were 200 metric tons, so not really significant. Under the CP, hire was not to contribute to GA. So actually, we are looking at this case from the charter's point of view. I think that this would be the more interesting point of view for everybody. So charter's point of view is that the charter's contribution was limited to the value of bunkers, about 200 metric tons, and only 5% of the freight which was unpaid, because 95% of the freight coming from subcharters was already paid and not returnable. The main conclusion from this is that once the vessel the ship declared, the master declared GA, then the vessel one, the original vessel, remained off hire. This was good news for the charters as it put them in a protected, safe position. What the master would need to do in these situations is provide access to a charter surveyors. The charters would have access to the logbooks. The voyage charters had issued a letter of protest to the ship. Now the interesting one, what are the owner's options when they have a broken ship in the middle of the ocean? What can they do in order to make life easier for everyone? Option one is discharge the cargo, repair the ship, reload the cargo on the repaired ship. That seems to be a very expensive option. The repairs could take ages. And in addition, there was lack of storage ashore. So option one was discounted. Option two is tow the vessel to the nearest port, which in reality wouldn't have helped anybody a lot. Option three is most of the cargo to be offloaded into a warehouse or another vessel, and some of the cargo be on board the vessel. That was discounted too. Number four is transship the entire cargo into another vessel to save the storage costs. Now, this was the option that was chosen by owners, and it turned to be probably the best option for the charters, because the owners, when they transship the cargo into a second vessel, would need to care about the chartering arrangements themselves. The owners would need to carry the cargo to the discharge port at the owner's expense. That's very important. The owners could claim these costs in GA, and then the charters would keep the freight they earned from the subcharters and be entitled to the balance of freight when the owners deliver the cargo. To simplify this, the most important thing for the charters is that they wouldn't have to pay hire for the second chartered ship. Now, when transshipping the cargo, unloading of the cargo would be general average. On carriage of the cargo may not be general average if the cargo is not perishable. What the owners tried to do in this situation is they tried to put pressure on charters to get involved in the transshipping and the chartering arrangements of vessel two. Charterers, through their solicitors, resisted that pressure, and they said, listen, we have nothing to do with your chartering arrangements of Vessel 2, which was a sister ship. You do that, you charter Vessel 2, you carry the cargo to where it has to go. We will sit and relax, and we will only contribute to GA with what is prescribed by the CP and York Antwerp rules, and that is bunkers and 5% of unpaid freight. So from charter's point of view, the Vessel 1 is off hire. The charters would have to place a bond, as we mentioned earlier, for their exposure. Charters were not concerned with how Vessel 2 would be chartered, and charters would only need to care about the subcharters posting a bond before the cargo was delivered. Now, what the subcharters may say to their direct counterparty is, hey, listen, the cargo is transshipped, so the cargo will arrive late at discharge port, and we would claim these delay claims from you. So that is potential exposure for our charters here. What else is interesting here? The Vessel 1, here is the tricky point. Vessel 1 has been sent for repairs, but under the original charter, Vessel 1 will have to complete the voyage. So when the Vessel 1 is repaired, the charters must decide in that case what to do. Now, prima facie, the Vessel 1, when repaired, should be redelivered at original discharge port. So the charters may say to owners, listen, our charter party is frustrated. Or they may say to owners, let's reach a commercial agreement to this. Now, the good news for everybody was that in the transshipment agreement, which I mentioned earlier, the Charter 1 obligation were terminated, which automatically transferred the charter party arrangements onto the charter for sister ship or Vessel 2. In simple words, the owners would have to sponsor the voyage of Vessel 2 or front the costs, because the subcharters will not pay freight twice. Vessel 2 will proceed with the voyage, deliver the cargo. The head charters would remain protected. They won't have to pay hire twice. And one last point before I reach the end of this story is a notion called custody of the cargo. Now, it matters very much who arranges the transshipment. If the owners arrange the transshipment of the cargo, then they will have custody of the cargo until the cargo is reached final destination. If the charters arrange the custody of the transshipment, which is not preferred for the charters, but if they do, then they would need to place their GA bonds and guarantees before the transshipment takes place. Now, nota bene, at the bottom, if there are delays in charters placing the bond and the guarantee, then the owners could claim hire because of these delays. So if you're a charter, you better place your bond and you place your guarantee with the help of your underwriters, with the help of your solicitors, with the help of ourselves, it may, if necessary. Be sure you act in time in order not to run into delays and be exposed to payment of hire. A final word, can general average be rejected by charterers? Yes, it can, if it's established that the vessel was unseaworthy at the beginning of the voyage. These things can be established through surveys, through expertise. So it very much depends on the technical state of the ship at the beginning of this voyage. Well, thank you very much for your attention. I hope this was interesting for everybody. I hope it was practical enough for everybody, not too academic. Please, let's get in touch. I am available either through Interlegal or directly for those of you who can find me. And I wish everybody a successful remainder of this conference.
Thank you very much, Yavor. It was really very interesting and very practically. And we have one question. I will read. If the ship cannot discharge in the port because the facility there is not yet completed, does the party who has ordered the cargo could claim GA?
Yeah, I'll try to answer that. Could you care to read the question again, please? Because the first part of the question.
I guess you can open questions and answers and read it.
Let me then stop sharing then.
Yes.
How do I stop sharing? I stop share. Okay. Right. Now,
Do you see?
just one moment. Give me a second. And then is it the chat box?
Not chat, but questions and answers near the chat box.
Participants, chat, record, question and answers. Okay.
Yeah.
The ship can't discharge in port because okay. Does the party who's ordered the cargo could claim general average? First of all, general average is claimed by the party which declares general average. The usual arrangement is that the carrier, the ship owner, declares general average. So the usual thing we see is that the ship owner's adjusters would prepare the adjustment certificate or reapportionment of the GA costs. So in other words, the initiative for the GA would very much come from ship owners, and they would be in the driving seat to stipulate who pays what. Now, the question is a good question, and it has relevance to the example I've given. In the example I've given, the cargo interests being at the bottom of the charter party chain or subcharterers have already paid freight. They've already paid for their transport. They've paid 95% of the freight and said, listen, we've paid our ticket for the bus. We want the cargo to get from A to B. We don't care what you do with it. The bus was broken, and there was a second bus made necessary for the completion of the voyage. Now, the cargo interests won't have to pay 2 times for the same bus to get their cargo from A to B. So if in a situation where the cargo interests were made or forced to pay twice the ticket for the cargo to be transported, then yes, they would be able to claim the second ticket or the second freight in GA. But if the second voyage is not funded by the cargo interests, but the owners front the costs, of their sister ship performing the voyage to final destination, then there will not be any extra exposure for cargo interests. They could stay at peace with what they've paid already, and their cargo will arrive at destination port. The only detriment or exposure for cargo interests would probably be the fact that the cargo will arrive late at discharge port. So they may claim the damages for the late arrival of cargo. I hope that answers the question to a big extent.
Yes, looks like. Thank you very much again, Yavor. And let me switch our second part of our webinar. Let me invite our panelists. At the second part, we'll have panel of 4 speakers, which will speak from different parties of maritime adventure, from different specific views. And let me introduce the first speaker, Yanis Voudouris. He is from Frederick University, Cyprus, and he will cover the topic about substitute expenses as per Rule F and 14 of York and Fairpenny rules. Yanis, please, you have 10 minutes.
Hello. Yes, thank you for the invitation. If you can hear me well.
Yes, everything well, but please switch on a slideshow.
All right. I will deal with the issue of.
Sorry, Yanis, yes. The slideshow doesn't work.
I have given the order, but perhaps it needs some time.
Ah, okay, maybe.
Yep. Let me see. Is it working now?
No.
For me, it shows. Okay. Let me. So it's the. Let me do it again.
Slideshow.
How? Stop share. How do I make a slideshow from the?
You have to switch on slideshow and then share the screen.
Okay. Slideshow and then share the screen. Okay.
Yes, we see your screen.
I
But
give the order, but is it on now?
maybe you can no, but maybe you can use the bar on the top.
Which is the order? So it is in the.
Yes, next, please.
In English, where is
English
it?
slideshow, but sorry, I can't read in Greek.
Okay, προβολή παρουσίας. Okay, got it.
Yes, and the left bottom start from the beginning.
Okay, what about now?
No translation. Do you have one screen or several screens?
One screen. PC screen only.
Okay, don't worry.
Okay, what about now?
No.
Okay, I tried everything. So
Okay.
Can we do it without slideshow?
Yeah, do it.
All right.
Okay.
Sometimes doesn't work. Okay.
Yes.
I will try to make it as big as possible. All right. So today, I'm sorry for this technical problem, but it was beyond my capacities. My name is Yanis Voudouris, and I will discuss the issue of due diligence as a reason for the cargo owner and for the cargo insurer at the end of the day not to make the contribution. So I will work with, I will just be brief and I will discuss with you the case of motor tanker Cape Bonny. In brief, that was a motor tanker that suffered a breakdown of an engine. The owners declared average, and the cargo owners managed to prove that the vessel was not seaworthy from the beginning. Therefore, at the commencement of the voyage, therefore, the owner was in breach of the contract of carriage as per Hague-Visby rules. Therefore, the owners, means the insurers, didn't have to pay the guarantee, the bond guarantee to the salvors. So that's the whole concept. Let me explain it in few words. Okay, so we have the Cape Bonny doing on passage between Argentina and China. There was an engine failure, and the contribution was assessed to the point of 2.5 million. to the amount of 2.5 million. So as we know, the general average is governed by York Adver rules. However, the parties in the maritime adventure, and this has a significance for the at the end of the day, the cargo owners that represent mostly the areas of the Baltic Sea, of the Black Sea, the owners of the cargo may not be liable to contribute if they can successfully prove that there was a breach of the contract of carriage. So if a vessel is unseaworthy, then there will be a breach of carriage. Therefore, cargo interests must prove unseaworthiness. Conversely, the owner, the ship owner, must prove that he has exercised the due diligence in maintaining his ship in good condition. Now, so after the engine broke down, everybody was asking what was the reason. In order to identify the proper reason, we need, in a sense, we need to identify through exhaustive, I would say, in a difficult situation, it's exhaustive and mechanical testing and research. So they asked the maker of the engine, and the maker of the engine could not determine what happened. So, by the way, this vessel was relatively new. But of course, they determined that there was a bearing failure. Now, the ship owner, after that, claimed that there was an inherent device, probably in the engine, that could not have guessed. He exercised all the due diligence, and because of a domino of bad luck, which makes at the end of the day the damage unforeseeable, then he may be excluded from liability. Now, so the court, and of course the cargo owners maintained the opinion that there was a fault of the ship owner side and submitted their technical analysis. And their technical analysis has been adopted by the court, and the court agreed that there was definitely an erosion on the crankshaft bearing that was due to the deflection of the crankshaft that was not that deflection created the overall breakdown of the engine. So first of all, the court found through the technical analysis that some of her filters were not seaworthy. Second, that was a considerable wear in the crankshaft bearings. Let me show you quickly, I prepared a video.
Modern ships are
What is more or less a crankshaft bearing for you to see. So I downloaded that a little bit. So this is the main piston of the, and as you see, this is the bearing of the piston. In order to measure the tolerances and the deflections of the bearing, this is the bearing, we have a tool. If the tolerances and deflections are large, then this is the tool, then the engine may break down. So should the engineers applied a proper reading and should have and through the reading have anticipated the damage, then they wouldn't have left the vessel to commence the voyage. Therefore, would have prevented the vessel to be unseaworthy. So the owner was unable to show that anyone had consciously considered the significance of these increases, and the cargo owner argued that, of course, there was a reading that was not beyond the scale, but cargo owner managed to support that, to establish that it was a rapid escalation of the whole thing that created the whole mess. And because of that, then the vessel was unseaworthy. And because of that, there was no due diligence from the side of the ship owner, as required by Article 3 of the Hague-Visby rules. So the court concluded that the prudent engineer or superintendent would have decided in 2011 that these deflection readings would have escalated to the point that a vessel wouldn't be seaworthy. So this decision serves as a useful reminder to the ship owners and operators for the importance of exercise of due diligence in making this vessel seaworthy. And it also shows shipboard engineers and shore-based superintendents that their actions and inactions can have far-reaching economic consequences. And also shows that the cargo owner may not accept general average so easily. And even if such a difficult cases, if he can actually support through a technical analysis that the vessel should not have commenced the voyage, then he's excluded from contributing. Now, who is the cargo owner at the moment? The representative of the cargo owner, the agent, in a sense of his cargo insurance. Thank you, and that's I try to be brief.
Thank you very much, Yanis. Maybe somebody has any comments? Maybe Richard? Yes, I felt.
Thank you, Yanis.
Hello, hi.
The due diligence to make a ship seaworthy has impact far and wide. The example I quoted, the vessel Mondo, was, surprise, surprise, was a Russian-class vessel. She was on a short voyage. Well, she was on a voyage Mediterranean to Ireland, and she had hull problems and went to Gibraltar as a port of refuge. The harbour authorities in Gibraltar would not allow her to go from Gibraltar to the Spanish port, which is not very far away, because the hull was dangerous. There was 75% wastage in the hull steel. The vessel was fully classed. Class requirements are for older vessels. Every 5 years, there has to be an ultrasound taken. To get to 75% would take more, 75% wastage, the thickness being reduced to 25% of what it should be, takes more than 5 years. The argument obviously was that this owner had arranged with the class society somehow to get a class certificate and continued on the voyage. Cargo underwriters refused the GA contribution because clearly to them the ship was unseaworthy. The Irish buyers had bought the cargo on a SIF basis. Under the Sale of Goods Act, and this is something under Section 32(2) of the Sale of Goods Act, a seller has a duty when he is selling the cargo to make a reasonable contract of carriage with for and on behalf of the buyer. If he doesn't do it, if he provides an unseaworthy ship, then Section 32(2) says that the risk does not pass from the seller to the buyer. We took this case to a trade arbitration, and I'm horrified to say the trade, I was not the arbitrator, I was a trade representative for this one. I'm horrified to say that the trade arbitrators accepted that by and on behalf of the seller, the fact that the vessel was fully classed on paper
Mhm.
meant that they had exercised due diligence. To my mind, that is extremely wrong. Yeah. And your example, yes, I agree totally with the result. The cargo could have looked to the Sale of Goods Act. Most bulk cargoes are carried on English law contracts, and made an argument under Section 32(2) of the Sale of Goods Act, and held the seller responsible for having an unseaworthy ship. The bill of lading, the risk under the bill of lading, the contract of carriage, would not have passed from the seller to the buyer. It would have remained with the seller. I just add that.
May I ask something?
Yeah, sure.
Because I'm learning at the same time. But where was the place of delivery? At the place of destination? At the port of
Ireland.
loading?
Port of loading, I think, was
that's
Turkey.
why.
It was a
That's
GA.
why.
She went to Gibraltar as a port of refuge.
Yeah, correct. It is the risk has not passed yet from the seller to the buyer.
Mhm.
And for our audience in general, if you are a charterer, you're probably also a trader. Bear this in mind if you come across an unseaworthy ship. Section 32(2) of the Sale of Goods Act may come to your assistance.
Thanks, sir.
Thank you very much, gentlemen. We have to go further because of the time. And our next speaker is Gennady Ivanov. He is director of BPG Shipping, the fleet operating company. And they had a general average case not a long time ago. So Gennady will talk about disponent owner perspective, what the main impressions, concerns, and lessons learned. Yes?
Yeah,
Please.
thank you very much, Nikolai. So first of all, it was very interesting to listen to all this information. Basically, as a charterer or discipline owner, like we act, you fortunately you don't face very often in my life, at least, with general average. Actually, I had for 20 years plus maybe 3-4 cases of general average, and basically, even when such case happening, you stay a little bit aside of the situation because the main pressure is on the shoulder of head owners. Basically, when you make a charter party, as disponent owner, during the conclusion of charter party, you must pay attention that in charter party is printed that hire is not contributed to the general average, only bunker. So basically, when general average the cases happen, like in our case, our vessel got failure with main engine in high risk area in the Red Sea, which made things more complicated. First of all, endangered for head owners, and during a couple of days, owners tried to fix the problem, but after 2-3 days, they decided to seek for the TAC assistance to bring the vessel to the nearest safe port. So basically, as soon as they made the salvage contract with the tax, they declared the general average. So the actions of charterers, the disponent owners, as soon as we got the official notice from head owners about the general average declaration, we immediately informed our club. Basically, we informed our Pendai club as soon as this case happened. I mean, owners declared the failure of main agent, and our Pendai club requested us the following information. They asked us to send us a copy of charter party with head owners, which we did, which is to be duly signed. They asked us to provide the information for any cargo on board, their quantity, their cargo documents, BL copies, and also they asked the question if we have our bunker on board. At the time, we had about quantity of bunker about 300 metric tons, which belongs to us as charterers. And also they asked if there are any other property of us on board. Definitely except bunker, we didn't have any property of ours. So basically, They also ask the request only the course of actions, the evidences, the timings, etc. So we provide all this information, and meantime, owners arrange the tax and brought the vessel to the nearest port, to shipyard. Then they perform the ship, the main engine repair. It's from my experience, also for previous cases, owners not always allow chartered surveyor to visit the port, or they try to prevent it or delay. So in this case, it was like that, but we strictly followed the instructions of our Pindai Club. And as soon as vessel was repaired, it took maybe 2 weeks. Vessel proceeded to discharge port, and like Yegor mentioned in his presentation, we faced with cargo receivers tried to put a claim for late delivery of the cargo. But they did it after vessel sailed, and they somehow linked this to the shortage. Despite vessel has a draft survey showing no shortage of the cargo, they try to implement this, connect this to the shortage of the cargo. So head owners in the first instance rejected this claim. In worst case, the exposure for us, this claim will go under interclub agreement. And basically, it's not a big exposure. So if we come back to the contribution, our part of general average is value of bunker board. So comparing to value of the ship and value of the cargo, basically, again, our exposure was very, very minimal and was mostly covered by deductibles as per our insurance. So basically, for general average, I can state that usually disponent owners, the charterers, are very much in between of any accident, any case. Yeah, but in terms of general average, I think it is a few cases when disponent owners has contribution only by value of the bunker on board. Of course, if you have bunker on board quite a significant value, you have a much bigger contribution. In our case, we had relatively small amount, so it was pretty much safe for us. So for disponent owners, it's very important to double check that in CP there is only bunker contribution for general average. Otherwise, again, it's the main pressure is on the head owners, and basically, as soon as this case happened and this situation came to the supervision of lawyers, we don't have much access to the consequences and the course of actions. So from time to time, we ask head owners in our Pindai Club for the update, but as understood now, this adjustment is in progress, and will be interesting for us, first of all, to see the final outcome. So that's all.
Okay, Gennady, thank you. So let me underline that it looks like your experience is not so bad. It's like a workable situation out there. Yeah? Okay, and our next speaker, let me introduce you, Mehmet Dogu, from Dogu Law Office from Istanbul. Mehmet, our partner, our Turkish partner, and he will make a comments from the Bosphorus and Dardanelles Strait perspective. Mehmet, please, floor is yours.
Hello, everybody. Good afternoon. The gentlemen, the speakers before me, they have extensively covered the principles, nearly all aspects, the principles and the practical issues with regard to general average. So your question is very general. So my answer will be very general at the beginning, probably. What happens is that Turkish law and practice follows the international practice of general average. So the principles applied in our local system doesn't change. I mean, we apply the Okamper rules, etc., in Turkish commercial code. The section is all based on the Okamper rules and the international practice. And if we consider Bosphorus and Dardanelles and Marmara Sea, the inland sea, which let me say altogether Turkish Straits, it really doesn't affect the application of any charter party which contains a clause with regard to the general leverage, which will say probably to be settled in London in accordance with your Canberra Rules 94, whatever. Usually, as Richard said, as recently 94 is more of we're coming across, but not the others. So in that sense, for example, a vessel has loaded some cargo from one of the Black Sea countries, let's say Romania, and then sailing to Italy or Morocco or somewhere, and then it has a general leverage situation within these Turkish straits. It really doesn't affect locally. I mean, local jurisdiction doesn't get involved. So whatever is stated in the charter party and bill of lading, that will constitute the relation between the interests, such as the ship interests and cargo interests, and if there are any underwriters involved, they will be obviously bind with that. Having said that, maybe there would be option for Turkish jurisdiction to get involved, and that might be still there is an existing charter party and bill of lading which contains the let's say, as an example again, adjustment to be settled made in London, your Canberra Rules, etc. But the vessel, while passing Turkish straits, has a general leverage situation, but the discharge port of destination is in Turkey. The practical issue would be, depending on the relations between the parties and depending on the case, cargo receivers, cargo interests may avoid providing general leverage guarantee and Lloyd's average bond. In this case, possibly the ship interests would like to defend their rights, would like to exercise lien on the cargo, first of all, and then if for some reason they want to continue their voyage and continue their trade, they would like to discharge it, but do not deliver the cargo to the receivers and would like to arrest the cargo through court. And in that case, the Turkish jurisdiction gets involved, Turkish courts. And as I said, the international practice is also applied in our system. So let's say we are acting on behalf of ship owners. Obviously, you go to court, explain the situation. You state in your application that you're going to discharge the cargo, put it in storage, etc. But you're not going to deliver the cargo due to this general leverage situation that you haven't received your general leverage guarantee and Lloyd's average bond. So that is probably the option when Turkish jurisdiction will get involved. Now, having said all these, in fact, it is another topic and a deep topic, extensive topic, that the salvage in Turkish straits, possibly more important because probably known by many of you, there's a monopoly of salvage. The salvage is performed in Turkish straits, including Marmara Sea, by the Coastal Safety and Salvage Administration. It's just a state organization, and they have their own salvage contract, which is called Turkish Open Form. What a surprise! And that they insist that that contract should be signed. Allow me to just go quickly through this. In practice, what happens is that something happens and there's an emergency response from the salvo side, the monopoly salvos. They attend to the casualty, and because under the circumstances, there's always like kind of things need to be done very quickly. So the ropes are exchanged, and they tow the vessel to a anchorage area, safe anchorage area, and then they insist that a contract should be signed whenever my clients are involved. This obviously from the ship owner side, because ship owners are asked to sign that salvage contract. I always suggest that don't sign anything, because in that contract it says that it's subject to arbitration, which the coastal safety always prefers. But on the contrary, if there's no contract, things go to the court, and they don't prefer that. So it's kind of a little bit of an advantage when it comes to that point. Nevertheless, our experience is that things settle amicably anyway. Obviously, the amounts are very huge comparing to the international practice in that respect in salvage cases. So going back to general leverage, as I say, probably doesn't involve Turkish jurisdiction at all if a vessel is sailing from a Black Sea port going to another port, not a Turkish port, but some other port, third country port. The general leverage, whatever happens, doesn't involve Turkish jurisdiction. I would say this would be probably the general answer for your question. If there is any other particular question that anybody would like to ask, I'm happy to answer.
Just a moment, Richard, please. Our participants had possibility to ask questions at the time of registration. And we have one question which I wish to address to you, Mehmet. I will read. Salvage fees, calculation and approval. In brief, please.
Salvo's fees.
Salvage fees, calculation and approval.
Okay. The state salvos, the monopoly state salvos.
Sure.
Yeah, of course.
Because we are talking about Turkish.
And you said that this question was put at the time of registry.
Of participant registration, yes.
Okay, perfect question, because he already or she already knew that the matter is salvage in straits rather than general leverage. Perfect. Well, the meetings commence, which you probably conclude in 2 days, 3 days maximum, receiving confirmations from your principals as a lawyer. During that couple of days, they mainly base their arguments on their past cases, saying that we have done a similar case, we have performed a similar service, and it was like, for example, 8%, 10% of the total values. So we would like to settle this case. And then if you put more scientific arguments, and then you try to show them that the service they provided is not that important, it's kind of roughly it can be said it was even a towage. Their position is very strong, being the state salvage company. So it takes a couple of days, but usually it ends up, the case ends up very close to their demanded figure. So I can't say that there is any specific measures or calculations they apply to their demand, the salvos. Of course, we all have in our salvage cases, I mean, it's in the law that it says that the equipment involved, the existing danger, whatever the services, how long it took, how many equipment or tugboats involved by the salvos. So these are kind of specs which can be used to establish the salvage award in general in international practice. But I can't say that you really can argue all these one-to-one when you're sitting at a table with those state salvos. So if this person at the time of the registry can have another question or more questions, please, you can write me. I can answer in more detail. Yes, the next question, please.
No question. Thank you.
Okay. Is this
Richard,
sure?
yes,
Okay.
please.
Yeah.
Just a question on jurisdiction. It's often, well, I've often
Oh,
seen-
sorry, Richard. Please put your microphone.
Oh, sorry. Oh, God.
No, microphone. I mean,
yes, sorry.
down, please. Oh,
Sorry, a question on jurisdiction, Mehmet. I've often seen bills of lading charter parties which simply say York Antwerp general average, York Antwerp rules to apply. If the port of refuge is Turkey, surely then the adjustment would have to be in Turkey.
Okay, this is a question. Am I correct?
Yes.
Well, you see, port of refuge is not always the last port. It might be a port of refuge. In that case, depending on the case, you might be discharging the cargo, going to a nearest repair facility, coming back, reloading the cargo, or just discharging the cargo, cutting the engine room, taking out the crankshaft, whatever the damage is. You know, like you don't leave the port of refuge, but do your particular average repairs within the port of refuge. And York Antwerp rule says that there's certain items which will be accepted as general average expenses. I mean, the crew wages, maintenance costs, plus some diesel generator consumption, partly the agents, etc. And obviously, the part of the discharging the cargo is solely for the purpose of the repairs done. So the discharge of the cargo, keeping them in storage, although you don't leave port of refuge, etc. But now, I think your question is aiming to ask me
Where
was
would
the last and no continuation of voyage.
Sorry. Your example is exactly the question. There's expenditure in Turkey, but the contract of carriage or the charter party does not mention adjustment to be in London. It simply says York Antwerp rules to apply. In that circumstances, would it not be right to say that the adjustment would have to be in Turkey?
Okay, excellent. I misunderstood. Sorry, I didn't understand your question in full.
Sorry.
Fine enough, no worries. Fine enough. The Turkish Code of Commerce says that the adjustment under the circumstances, how you mentioned, the adjustment is prepared at the end of the voyage, at the port of arrival. So if under these circumstances, there's no London adjustment is mentioned, in this case, you can insist that one of the parties may insist that it should be done in Turkey, which legally will be valid because there is no agreed any place of it. That's it.
Okay, thank you for that. Just a clarification.
okay. Thank you so much.
Please, you're welcome.
And finally, let's talk about general average from cargo point of view. And I wish to introduce you Alexander Chebotarenko, Maersk Ukraine, Chief Legal Advisor, and frequently asked questions from Maersk customers. Please, Alexander, the floor is yours.
Hello, everybody. Do you read me well?
Yeah, nice, perfect.
It's a great pleasure to be in such a good company today. Pleasure and honor. As a representative of container line, I have chosen the most frequent asked questions from our customers, cargo owners' interest. But before coming to the questions and answers, I would like just to remember again that customers or cargo owners are strictly advised always to attentively read their terms of carriage and try to remind that in clause 24 of terms of carriage, in particular of Maersk, general average are covered in that clause. So also when Maersk may be a ship owner or an operator or in other quality declares a general average, our clients are always advised with instructions from the line and from the adjusters. And we also strictly advise to attentively read those instructions, because all the information and documentation forms are provided in order to further be completed, and guarantees are presented. Now let's come to the question. So I have chosen a couple of most frequently asked questions. The first one is once full security. That's this. If insurers are given a guarantee, why must the cargo often be required to also sign an average bond? 2 points here are to be underlined. First, the average bond establishes the identity and contact details of the receiving party, so that it can be contacted if necessary after delivery of the cargo. For example, for particulars of the goods. Further, the GA bond establishes a promise to pay, which in its turn triggers the liability of the cargo insurers. The next question is, what if the cargo is not insured? In majority cases, the cargo will be insured, but there are some cases when cargo is not. In case the cargo is not insured, it is required a cash deposit from the cargo owner instead of GA guarantees. An average bond also should be provided. The amount of the deposit will be established in percent to the sound value of the goods. The percentage will be advised by the GA adjusters as soon as possible, as the, for example, salvage services are complete. The cash deposit will be held by the adjuster on the special trusted account. Once adjustment is complete, funds will be released to pay to the relevant parties, and the remaining balance will be refunded to the depositor. The next question. Once full security has been given, how will one know that cargo can be released? I would like to remember that shipping line, the container line, remains the interface and the contracting party to the customer, and it generally, at the end of every working day, the general average adjuster is expected to send a list of fully secured cargo that has been released from the control. Such a list may be uploaded by the adjuster on their website. It also is on the website of the shipping line. The list of the released containers also may be obtained from the customer service desk, our customer service desk, for example, or maybe on a regular basis sent to the customers. So this is not a problem to be updated on an everyday basis here. The next question is, what happens with consolidated groupage containers? Okay, LCL containers, just remind that those that contain several shipments may be released, may not be released until security has been provided for each shipment contained in this container. The freight forwarders or the agents responsible for such bookings are proposed to contact the carrier as soon as possible with a breakdown, with a list of contents of these containers, so that options for provision security and options for delivery such containers could be discussed with the carrier. So that's all as to those questions for me. Maybe you have some.
Yes, thank you, Alexander. And please look into the question and answers part of Zoom. At the bottom of your screen, there is a button, questions and answers. And there are two questions.
If the shipment is complete damage, does the owner of the shipment have to participate in the general average security? Cargo owner is meant.
So there is no cargo after the accident or after the something which brings general average, yes?
I see. So yeah, the cargo owner should participate in general average and should provide the average bonds in any case. Okay. But this is up to adjusters here to make calculations and to establish the contributions for each participating party. But anyway, the cargo owner should at first stage should provide an average bond or cash, an average bond and guarantee and bill of lading and invoice and many other documents, just as it would be instructed by the adjuster and the shipping line.
But let's say good news that his losses will be counted into the GA.
His losses will be accounted.
So not only bad news for him.
Yeah.
Okay, and second question, how the GA declaration affects the usual 1 year time bar for cargo claims?
Well, the GA declaration affects. How the GA declaration affects the usual 1 year time place. You see,
I can
it's
answer.
difficult to answer for me.
Yes, I can answer that. First of all, this depends on applicable law. If we are talking about local law at the final port, we can look into the local registration. But if we are talking about English law, the usual 6 year time bar is applicable to this kind of claims. Richard, am I right?
Oh,
we are talking about time bar for GA claims, and I just talked that if we're talking about London, the usual 6 year time bar is applicable. Yes, please.
Time limits in the York Antwerp rules should not be confused with the Hague-Visby time limits. Under my understanding, under the 2016 York Antwerp rules, is if there is an argument over time limits about the GA adjustment, that it's a 12-month period. If the property interest does not say anything to the adjuster, then it becomes open. The adjuster is given virtually carte blanche to make a valuation or do something in the adjustment.
Mhm.
It's don't confuse the Hague-Visby 12-month limit with time limits under the York-Antwerp rules.
Thank you very much.
Можно один вопрос?
Yes, Gennady, sure.
By using this opportunity to be these professionals in situation when owner is not a carrier as per bail, what could be the procedure of contribution? For
Sorry,
example,
when the
there
owner-
are some situations when we are talking about dry bulk carriers, not containers, when owner is not a carrier, as per bail is not a carrier. Carrier is charterers.
Yes, well, a voyage charterer or time charterer.
Time charter.
Time charterer is
Very rare cases, but it happens.
very rare cases. The time charterer, my understanding, and I hasten to add, I'm not an average adjuster. My understanding for a time charterer is his only contribution in GA would be the value of the property he has at risk at the time of the incident, the bunkers. A voyage charterer, it's different. He may be participating in the voyage, but the contracted carriage in question would be the bill of lading, which takes it back to the cargo owner. But just to be a caveat on all of that, I am not an average adjuster, but that is the way that I've dealt with it in the past.
Mhm. Okay.
Thank you.
Okay, gents. Thank you very much. I would like to tell to audience that today we had two speakers, Richard Faint and Yavor Velchev, and then we had four panelists, Yanis Voudouris, Gennady Ivanov, Mehmet Dogu, and Alexander Chebotarenko. Thank you so much. And please follow our advertisement. We will continue our webinars this year, next year, and hope long time, for long years. So thank you so much, and see you next time.
Thank you.
Thank you very
Bye-bye.
much.
Bye-bye.
Bye.
Thank you. Bye bye. Bye bye.